All right, we should be live.
Thank you very much. Welcome to the Judiciary Committee on this Tuesday, March 14th. Had an interesting morning with our power outage, which put us a little behind in the morning, but we're back on target, at least for what we're planning on taking up this afternoon, which is H230. And we have a number of witnesses still on version 4.1, which is what we received from the Healthcare Committee. And we are going to start with, is it Eliza or is it Eliza Doucet? Or can you pronounce your name for me, Eliza?
Yes. I'm Eliza Doucet.
Excellent. So we're going to start with you, and if you could identify yourself for the record and proceed. Really appreciate you being here.
Yeah, thank you. I'm sorry I couldn't be here in person. Just was snowed in this morning. So.
Yes.
Okay. Chair Lalonde and members of the House Committee on Judiciary. My name is Eliza Doucet. I am a junior at Mount Abraham Union High School, which is located in Bristol, Vermont. And today I'm here representing Gun Sense Vermont, which is a 4,000 member advocacy organization committed to reducing gun violence. First of all, I want to thank you all for having me today. Listening to the voices of youth like myself is truly the only way to move forward towards a safer state. To start off, I want to express my complete support for H230. As you all know, H230 would prevent suicides by implementing a waiting period following the transfer of firearms between owners, and by requiring firearm owners in homes where children or at-risk individuals could access them to store these dangerous weapons locked and separated from ammunition. Sometimes people ask me about what lawmakers are doing to help the gun violence epidemic and how I feel about it. I want to be able to tell them that lawmakers in Vermont are doing the right thing and is taking action to save lives. In the past, that wasn't necessarily the case, but I hope that my presence here today is a starting point off of which change can happen. Suicide prevention is essential everywhere, but especially in Vermont, where, according to the Vermont Suicide Prevention Coalition, the rate of death by suicide has consistently been 30% higher than the national average over the past 15 years. These past 3 years have been difficult for many Vermonters as we face isolation, financial stress, loss, increased stress due to COVID-19. All of these factors have been repeatedly linked to higher rates of depression and suicide, which makes it all the more important that we act now. Personally, I've suffered from depression for much of my life. And my family does not own a firearm, which I am incredibly grateful for, because even when I feel like I'm on the verge of a crisis, I know that I'm as safe as possible. I don't want to imagine what could have been if I lived in a place with immediate access to firearms. So thank you for considering this important bill. Vermont is currently the only state in New England without any sort of safe storage law. And I'm so grateful to everyone who's in this room and on Zoom who will vote in favor of the H230 and therefore in favor of saving lives. For those who may not be planning on supporting this bill, I want to remind you that voting against H230 is voting against protective measures for the constituents that you were elected to protect. When you cast your vote, please remember my words and remember what is at stake here. The truth is, H230 isn't about guns. It's about saving lives while maintaining the freedoms and a culture around safely used firearms that Vermont holds so sacred. Although I am grateful for and fully in support of H230, I want to leave you all with the thought that H230 isn't going far enough. H230 doesn't mandate safe storage for all firearm owners, which means that adults who may not have been identified as high risk or who may have never before experienced a mental health crisis and find themselves in one at present time can access firearms. Furthermore, H230 only requires a waiting period of 72 hours before the transfer of firearms between owners. So this means that any sort of extended mental health crisis could still very easily end in death by firearms. And it's also important to note that firearms have a much higher death rate in proportion than any other method by which people may attempt to commit suicide. So to finish off, I want to urge you to keep fighting for it right, no matter how many of your colleagues might push back. Please, please, please join me on the right side of history. Thanks.
Thank you very much. Are you available if anybody has questions?
I am, yes.
Any questions for Eliza? I don't see any questions right now, so very much appreciate your testimony. And if we have other questions, we know how to track you down to ask them. So I really appreciate it. Thank you, Eliza.
Okay, thank you so much.
And we're going to move to Dr. Rebecca Bell next. Thank you, Dr. Bell, for being here. If you identify yourself for the record and proceed.
Sure. Yes. Hi. Hopefully you can hear me okay. I'm Dr. Rebecca Bell. I'm a pediatric intensivist at University of Vermont Children's Hospital, and I'm the president of the Vermont chapter of the American Academy of Pediatrics and the president-elect of the Vermont Medical Society. And I am here on behalf of those two organizations that I help lead in support of H230. And I want to also note a few other Vermont medical organizations also in support. And those include the Vermont Academy of Family Physicians, the Vermont Psychiatric Association, and the University of Vermont Health Network. And so as Vermont medical professionals, we are really concerned about our high rate of suicide death. And this is, we have a higher rate than the national average among all age groups. And I'm going to talk a little bit about some of the work that we do to try to mitigate that. And what we feel H230 would do would be to help augment and complement our work. And so there isn't one thing that's going to...
Uh-oh. So I think on your end, we just lost you, Dr. Beck. So Panina, are you still? Oh, yeah, there you're back. You went over for a second.
Okay. I'm not having any. I'm not having any messages on my side that my connection is unstable. So just thank you for speaking up and just let me know if that happens again.
Okay. Great.
So I testified before the bill was created. I testified with a colleague to House Health Committee about suicide in Vermont in general, and specifically around lethal means and the connection between impulsivity, suicide, and access to firearms. And that's a bit of a longer talk, which I'm not going to go through today, but something that's on the record that could be looked at. But I did submit some highlights in my testimony and with some references. And I thought I could just talk a little bit about my experience, because what I see clinically is very similar to what the national literature shows, and then sort of answer questions. So I come at this work, again, as I work in the pediatric ICU. And so I care for critically ill or injured infants, children, or adolescents. We're the only pediatric intensive care unit in Vermont. And I do care for young people who are require ICU care for their suicide attempt. I also sit on the state child fatality review team. And so part of our work is to review all unexpected child deaths in the state of Vermont, including suicide deaths. And what I have come to see both in my clinical work and as part of this group, I also sit on the Vermont suicide prevention data work group, is that there are really different populations of people who are affected by this, and it requires a multi-pronged approach to address this. But one really important approach is thinking about access to firearms. So I initially, before I sort of started this work, imagined that suicide deaths could be predicted both at a population level and an individual level by certain risk factors. And what I have found personally, and what the literature shows us, is that unfortunately that is not the case. That the things that we think would predict whether a population is more at risk for suicide death or an individual is more at risk for suicide death is sort of weakly correlated. And by that, I mean, one might imagine, and I think this is how most people think about suicide, is that if you think about it as sort of like a pyramid, that you've got your population at the bottom, at your base, and then that you might have a certain percentage of that population that might be afflicted with, say, depression. And then of that population, you have folks who have suicidal ideation. And then of that population, you have folks who attempt suicide. And then at the top, you have those who die by suicide, with the idea being that those who die by suicide are like the most afflicted, they're sort of the sickest, and that pyramid sort of goes like that. And that's actually not the case. In fact, in Vermont, our pyramid, when you compare it to other states, is really top heavy. So we have more people die by suicide in Vermont than would be predicted based on our levels of things like depression, feeling sad or hopeless, suicidal ideation, or even suicide attempts. So does this even make any sense? How can you have a population that has fewer suicide attempts but a higher death rate? And that's when we really need to think about means and the method used and the lethality of the means. And so in Vermont, when we look at suicide deaths, the most common method used are firearms, and that is more common than all other methods combined. So you take any other method of suicide, you add those up, you still have more firearm suicide deaths, and that's because firearms are lethal. And when we look at lethality and think about lethality in the medical community, we think about a few factors. One being just the inherent deadliness of the method, the accessibility, the ease of use, and the ability to abort mid-attempt. And firearms do not allow somebody who is attempting suicide to change their mind. They cannot abort the attempt once it's started. And what we found is that when we look at a population level, like if we look at our young people, we have really good data every other year for decades on how our young people feel around suicide ideation and suicide attempts. So we get this data through the Youth Risk Behavior Survey. All middle schoolers and mostly all middle schoolers and high schoolers in Vermont and across all states take this survey. And what we see is that our young people report, in comparison to other states, they report lower levels of feeling sad or hopeless, suicide thoughts, suicide planning, and suicide attempts, yet they are dying at a higher rate than the national average. And so at a population level, we really can't predict who's going to die by suicide. And that is also true at an individual level. So as medical professionals, we really want to be able to look at the patient in front of us and understand what their risk level is for dying by suicide. And we unfortunately are unable to do that with a good degree of predictability. And that makes our work really hard. And what we've come to realize is that, again, the method used is really, really important in whether our patients live or die in a suicide attempt. And so reducing access to lethal means for a suicide attempt can do that. So I don't know if people have my remarks, but I have a flow chart on the last page that sort of walks through the idea behind reducing access to lethal means and how that can save lives. And so I'll just walk you through it, but you can sort of think about this both with a waiting period and also with a safe storage or child access prevention law. And that is that when you have a highly lethal method, so like firearms, and that method is now inaccessible to somebody, whether because firearms were removed from the home, whether they're locked up and inaccessible, or whether there's a waiting period to purchase the firearm, then one of two things happens. One is, and this happens more commonly than you would think, one is that the attempt is actually delayed. And so there's oftentimes a thought, well, if somebody has a thought in their mind that they want to die by suicide, they're just going to find a way. So if they can't get a firearm, they're just going to find another way to do it. But that's not actually what we find. We find that sometimes just thwarting the plan in their mind is enough to actually make no attempt. Or they will substitute the method, and any method that is substituted for a firearm is by definition going to be less lethal. And so there's more of a chance, based on those like 4 aspects of lethality, that the person will survive. And then what ends up happening is, we have that suicidal crisis may pass, and you have fewer deaths overall. So this is the idea behind reducing access to lethal means and how this affects suicide rates. When we look at those who do die by firearm suicide, the other aspect of this that most people think is, well, if somebody chose a firearm in their suicide attempt, they must have been really intent on dying. And we actually find the opposite to be true, which is hard sometimes to wrap our minds around. But when researchers look at people who have attempted suicide with a firearm versus other methods, what they find, and this is true when I look at my cases in Vermont of young people, what they find is when they compare those 2 groups, that those who choose a firearm are doing so more impulsively than those who choose another method. So they've thought about it for a shorter amount of time. They planned for it for a shorter amount of time. They are less likely to have a mental health diagnosis. They're less likely to be involved in the mental health system. And they're less likely to have made a prior suicide attempt. And so for us, when we're thinking about keeping our patients safe, that doesn't give us a lot to go on. So if these are folks who are less likely to have made suicide attempts or have maybe contact with the medical community, that makes it hard to keep people safe. And so although for a long time we've recognized the association between suicide and say having a firearm in the home, and thinking about how, when our patients are in crisis, how to talk about keeping them safe, what we've now come to realize is that we really need to do this more universally, because many of these attempts are happening very impulsively, and it is challenging to respond in enough time. And so in pediatrics, we now understand that we really need to be having conversations about safe storage with our families universally all the time, because we cannot predict when adolescents or children are going to have a crisis and make a suicide attempt impulsively. This happens in Vermont because of an argument with a parent, of a breakup of a relationship, of something happening at school, seeing something on social media. All of those things have resulted in suicide deaths, and they happen very, very impulsively. And so what we have been working on in pediatrics is, how do we counsel about safe storage in the home? So we know if firearms are stored locked up, unloaded, with the ammunition stored separately, those are protective factors and reduce the risk of suicide and also of unintentional shootings in the home. And so this is something that we talk about with our patients, and we have found that this is something we haven't been very well trained at. And so we have new tools over the past couple of years that I've been lucky enough to work on, both regionally and nationally, and how we have these conversations with families, so it's non-judgmental, and so it can actually affect behavior change. And recently, the University of Vermont Health Network has partnered with a bunch of different stakeholders and organizations throughout the state. And this effort was led by the U.S. Attorney's Office for the District of Vermont to put out PSAs on safe storage of firearms in the home, and then encouraging folks to remove firearms from the home if there are any concerns for safety. And that has been a really nice effort that went forward. I have links to the website that came out actually a couple of weeks ago. And so there's this broad understanding that through many different stakeholders and through many different ways, we need to talk about safe storage, and we need to talk about giving people time and space so that an impulsive act doesn't lead to a death. So I'll just add that I mentioned the Vermont medical organizations that support these H230, and that I'll just add that broadly, that national medical organizations also support things like waiting periods and extreme risk protection orders and safe storage laws or child access prevention laws, because they increase the safety, health and safety of our patients. And there are no drawbacks. There are no trade-offs in terms of health and safety. And so I know that for your committee, for Judiciary Committee, you're considering other aspects of the law. So the legal aspects, there are cultural aspects, there are convenience aspects. All of those are true and should be acknowledged. But in terms of health and safety of our patients, this is an easy thing to get behind because these measures increase safety without any trade-offs at all. And so I think I will stop there and see if anyone has any questions.
Thank you very much. Any questions? Okay. Oh, I thought you raised your hand. I don't see any questions. Thank you very much for that information. Really appreciate that. And we have questions that come up. We'll contact you. Oh, actually, I do have a question over here. Joe.
A quick question, thanks. I was wondering if you might be able to direct us towards the data regarding, you had mentioned in your written testimony, sort of trying to formulate the question as I'm talking, but you had mentioned in your written testimony that Vermont has higher than average youth suicide death rate when compared to other states, but lower than average suicide prevalence rate of youth reporting severe depressive symptoms, suicidal planning, and suicide attempts. And I noticed that there was a footnote there. And so I went to the footnote, which is the 2019 data from the Youth Risk Behavior Survey. And I noticed that this particular table that was linked has both Vermont and the United States, but there was data missing regarding a suicide attempt resulted in an injury, poisoning, or overdose that'd be treated by a doctor or nurse, which seems to be the highest level it tracks, at least in this particular survey. And so I was just trying to find that data because I'd like to be able to look at that myself and see how that all shakes out.
Yes, and I can send just to the whole committee links to play around with some of this data. I know exactly what you're talking about because I was trying to find the best link to put in here for you all. But some of that results in the fact that Vermont, there are pretty standardized youth risk behavior survey questions, but some states do ask the question a little bit differently. Mm-hmm. So the standard, the 3 questions that we have in Vermont that we can compare to the US, and I just would have to send you all 3 tables, are have you felt, it's about having severe depressive episodes over the last year, thoughts of suicide planning, and suicide attempt. Mm-hmm. So the other piece that you asked about resulting in bodily injury, that one we don't have recent data on that specific question, but we have on those other ones that I mentioned, and we're consistently below the national average for answering those questions. I will just point out, this is not your question, but all those numbers are going up. So they're concerning numbers, and I take care of a lot of young people who are experiencing a lot of distress. And so those are really problematic numbers that are going up, but Vermont relatively consistently always has lower self-reported scores than other states. And so what this is just really showing is that suicidal thoughts are they're predictors of distress, right? That makes sense. But they're not predictors of suicide death. And that's true in adults as well. So because the lethality of the method used during a suicide attempt is so important, it's more predictive of a death than like intent. So when you go back and researchers talk to people who've survived their suicide attempt, they find no correlation between the medical severity and really intent. So intent to die, different levels of remorse and regret afterwards. And so that's a piece that if we want to move the needle on suicide deaths in Vermont, we really need to address the firearm deaths that happen in many cases very impulsively. But I will go back and what I'll do is probably just send different links to each of those questions so that you can see the difference between Vermont and the US. And the data is there for like many, many years going. It's every other year. So we've got tons of data on that.
Great, thank you so much.
Great, thank you. Other questions? I think we're all set. And if you could send that to Panina, that would be great. She can then post that as well. So appreciate it.
Will do. Thank you very much.
All right, we are going to skip over Eric Davis. He's unable to be here today, so he will be testifying tomorrow afternoon, and we'll move on to Billy Clark. If I assume that you're on there. There you are. Excellent, excellent. So if you identify yourself for the record and proceed.
Absolutely. Good afternoon, and thank you all so much for the opportunity to speak with this committee. My name is Billy Clark, and I'm a litigation attorney at the Giffords Law Center to Prevent Gun Violence. Under the leadership of former Congresswoman Gabrielle Giffords, Giffords Law Center researches, drafts, and defends the laws, policies, and programs proven to save lives from gun violence. I work remotely for Giffords from my home in Burlington, Vermont. I'm a licensed Vermont attorney who previously worked in the litigation group at Downs Racklin Martin in Burlington, where I litigated cases in state and federal courts across Vermont. Before that, I served as a law clerk for a federal district court judge and then for a federal appellate court judge, both in Boston. So my goal today is to lay out the framework for evaluating the constitutionality of the provisions of H.230 under both the Second Amendment and Article 16 of the Vermont Constitution. I want to explain why these laws fall well within the state's power to promote public safety and do not infringe on any constitutional rights. In so doing, I will direct you all to some historical materials and context that support all three provisions: the safe storage laws, ERPOs, extreme risk protective orders, and waiting periods. But if you take away one thing from my testimony today, it is that the Supreme Court's decision in Bruin does not prevent you from passing common sense gun violence prevention laws like H.230. States can and must continue to exercise their traditional police powers to fight the epidemic of gun violence in this country. So I want to begin with Article 16 because I think it's important to begin with the Vermont Constitution. You know, a lot of the discussion around the Second Amendment actually involves the Vermont Constitution. Article 16 is our state constitutional right to bear arms, and it's a right that predates the federal Constitution. It was just us in Pennsylvania who predate the federal Constitution in that way. And Article 16 says that the people have a right to bear arms for the defense of themselves and the state. And actually, in that way, it more directly grants an individual right to bear arms, some might say, than the Second Amendment, a point that was sort of discussed in both the Heller majority opinion in District of Columbia v. Heller, which is one of the court decisions I'll talk a little about in a second from the Supreme Court, in both the majority opinion and in the dissent. And there really hadn't been too much case law from Vermont about Article 16 until very recently. There was basically two cases before a case 2 years ago, State v. Mish, which I'm sure you're all familiar with. But in that case, in State v. Mish, the Vermont Supreme Court adopted the reasonable regulation test for evaluating Article 16 claims and held that the Vermont's ban on large capacity magazines was a reasonable regulation that did not infringe on the right to bear arms. And I want to talk about this test, even though it's different than the Bruin test, because I think it's important to go with, you know, first and foremost, we have a duty under the state constitution to pass laws that comport with the state constitution. And then we also have a duty under the Second, you know, to not violate the Second or 14th Amendments. But I think it's important to think about what the reasonable regulation test actually calls for. And what that calls for is, you know, it just requires the statute to be a reasonable exercise of the state's police power. It requires that the purpose of the enactment be in the interest of the public welfare and that the methods utilized bear a rational relationship to the intended goals. So that's from State v. Mish at paragraph 64. And importantly, you know, because there's a discussion of, you know, means end scrutiny. And for all of us who've been to law school, you know, that's the big thing of con law is all the different balancing tests. And while the reasonable regulation test sounds similar to what's known in the federal system as the rational basis review test, it's actually different, and it actually has more bite. And the Vermont Supreme Court and State v. Mish made this clear. The reasonable regulation test requires, quote, an actual, not just conceivable, legitimate purpose related to the health, safety, and welfare of the people. It focuses on balancing the interests at stake rather than on merely whether any conceivable rationale exists under which the legislature may have concluded that the law could promote the public welfare. And I bring this up because, you know, I know, as we'll get to with Bruin, there's this discussion of history. It all has to be history. But remember that you have an independent duty under the Vermont Constitution to consider the public health, safety, and welfare of the people and how these laws promote that health, safety, and welfare. It would not be enough under the Vermont Constitution, at least in my view, to say, well, they regulated like this in 1791, therefore we get to regulate like this today. You still would have an obligation to consider, and a court would look to whether the legislature did consider the legitimate purposes that are underlying the laws. So, all that great testimony from Dr. Bell and all the other testimony that's been taken in the other committees on this, is in my view, very relevant to the constitutionality, at least under the state constitution. But to get to the heart of the matter, I want to get into Bruin, which, is obviously what hangs over all gun regulation in this age. To give a brief, history, the U.S. Supreme Court had never held that there was an individual right to bear arms until 2008, when it decided its seminal decision in District of Columbia v. Heller. And in that case, the court, adopted just announced that there was a right and didn't explicitly say how that right would be balanced in courts, how evaluating courts would consider whether a law violated the Second Amendment, just, held that the District of Columbia's ban on handguns violated the Second Amendment. And it wasn't until this last year in Bruin when the Supreme Court finally came down with the standard that courts would use going forward to evaluate Second Amendment claims. And I know this has already been introduced, but I'll just repeat again sort of the key language from Bruin on this. So this is the key language. Quote, when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearms regulation. So that's the standard that we got in Bruin. And we'll get to a minute of how courts have sort of started to break that down. But I want to make clear, the limitations of Bruin. So there were several concurring opinions in Bruin, one from Justice Alito, who was very clear that the narrowness of the decision, and then another important one from Justice Kavanaugh, which was joined by Chief Justice Roberts, that went back to this language that's been relied on heavily from the District of Columbia v. Heller, the first decision that held there was an individual right to bear arms. And I want to go to what this language from Heller is, because it informs a lot of what we're going to be talking about today. Heller set forth some, quote, presumptively lawful measures that would not violate the Second Amendment in order to give some guidance to lower courts as to, what laws would violate and what laws wouldn't. And so in the Heller opinion, which again is, referenced in Bruin as not being overruled and not being changed, nothing's being altered from Heller in Bruin, the Supreme Court wrote, quote, like most rights, the right secured by the Second Amendment is not unlimited. From the 19th century, commentators and courts routinely explained that the right was not a right to keep and carry any weapon whatsoever, in any manner whatsoever, and for whatever purpose. And then skipping down, there's another part from Heller. Nothing, in our opinion, should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places, such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. So I flag all of those because it's going to inform our discussion later. Those sort of laws, possession by felons, regulations on the commercial sale of firearms. Heller was clear, nothing in those opinions should cast doubt on those regulations. And again, said that they were presumptively lawful. So we have this Bruin test, which I'll go through, and we'll go through how that works with all the different provisions in H230. But again, we need to keep in mind that that key language from Heller was not disturbed by Bruin. So again, I kind of want to break down the way that the Bruin test works. And one of the cases that I included in the materials was a recent federal decision from California called United States v. Tallada. And I included that because it's very helpful in framing how courts have started to apply Bruin. And in this way, sort of the 2 or 3 part way that Bruin is getting applied. So I would direct you to pages 4 and 5 of the PDF that I circulated in the Tallada decision. That's where I'm going to be going from this section. So in Tallada, the court talked about how if you're going to analyze a Second Amendment challenge post-Bruin, there's sort of 3 steps. First, the court needs to precisely define the defendant's proposed course of conduct, or the challenger's proposed course of conduct. What is the conduct that the person who's challenging a law says is protected by the Second Amendment? What is their course of conduct? Second, the court should analyze whether the plain text of the Second Amendment covers this proposed course of conduct. So go back to the plain text of the, recall that in Bruin, they said, when the plain text covers conduct. So you have to look at, okay, the plain text of the Second Amendment says keep and bear arms. Is this proposed course of conduct a part of keeping and bearing arms? Most notably for the purposes of self-defense, which is what both Heller and Bruin said is the key component, the central component of the Second Amendment right. And then so last, after you've done this proposed course of conduct and plain text analysis, then do you turn to history. Only then do you turn to history. A challenger has to show that they're within the plain text of the Second Amendment, according to the proposed course of conduct. And only if they're able to make that initial showing does the government then need to justify its regulation based on historical tradition. And again, I'll give you a little bit of language from Talata, because again, it informs this discussion. A litigant could not reasonably argue that Bruin stands for the idea that the Second Amendment right is unfettered and that Congress or state legislatures are powerless to regulate firearm possession, much less firearms sales. Because a law involves firearms does not mean that the Second Amendment is necessarily implicated. So again, I just want to start with that, and now we can sort of start to go into the specific provisions of the law, unless anybody has questions about sort of the general analytical framework. I'm hoping that as we go through the specific provisions, that'll become clear, but are there any questions about the overall analytical framework?
Any questions? Yeah, Joe.
Could you just give me a pin site to the 3-part test in Bruin? I'm trying to find it myself here, but a lot of Bruin to go through.
Yes.
You could just pin site it.
So yes, it's on 142 S Court 2129 to 2130.
129 to 2130.
Yep. And then Talata's discussion of it, which I think is very helpful, is at 10 and 11 of the slip opinion. And on your PDF that I've supplied, it's on pages 4 and 5.
Great. Yeah, unfortunately, the slip opinion on the Supreme Court's website for Bruin doesn't have the 2129 to 2130, unfortunately. So I can't find. You know what section it was in?
Yeah, let me find it for you.
Thanks.
Okay. I can do that. Yeah, we're starting to get it all publicized, but let me see if I can find that for you. So the one that would be on the Supreme Court's website, it would be at page 15 of the one that would be on the Supreme Court's website. It would be right at the top, just before section C.
Awesome. Thank you so much.
Yeah, of course.
Any other questions before we move on? No, looks like we're good. Go ahead.
Okay, great. All right, so then let's start with the safe storage part of the bill. So to sort of summarize the language of that, what that does is, it says a person shall not store or keep a firearm within any premises under their custody or control if the person knows or reasonably should know that a child or prohibited person is likely to gain access to the firearm unless the person, stores it securely. That's what the next provision says. So let's go to that, the Bruin test and break down what it would be. So let's start with what's the proposed course of conduct? Well, someone who would be challenging this law would say that they have a right to store or keep a firearm in a place where a child or prohibited person they know may gain access. And so that's the proposed course of conduct. Again, this is where you need to be specific in defining it. If defined at the level of generality of, well, it infringes on keeping and bearing arms, then yes, it would imply the plain text. But that's not what this does. It's more limited. It's not, as Eliza mentioned in her testimony, it's not safe storage in all contexts. It's in the context of when there is a child or prohibited person who the person knows or should know is likely to gain access. So under that narrower definition of the proposed course of conduct, does that implicate the plain text of the Second Amendment? Well, respectfully, I would submit no. I would say that while the Second Amendment protects a right to keep and bear arms for self-defense, let's go back to that language from Heller, which said it's not a right to keep and carry any weapon whatsoever in any manner whatsoever. And carrying and keeping a weapon in a way that a child or prohibited person, such as a felon or someone subject to a domestic violence order or any of those sort of things, could gain access to it, strikes me as not what the Second Amendment is about. The Second Amendment is about protecting, Bruin has other parts where it refers to the right of ordinary law-abiding citizens to engage in self-defense, to keep and carry for self-defense. So in my view, no, this does not implicate the plain text of the Second Amendment. And it wouldn't, that proposed course of conduct would not be covered. And at that point, a challenge would end there. There would actually be no need to do a historical tradition analysis after that. Fortunately for you all, as we always do as lawyers, pleading in the alternative, there is a lengthy historical tradition of regulating the safe storage of firearms and things related to firearms. This was talked about at the last hearing a little bit, so I don't want to dwell too long on it, but there's a lengthy number of, I believe it's 193 historical laws involving the storage of gunpowder that are listed on the Duke Repository of Historical Gun Laws website. And what I've done is I've included the PDFs of the actual laws. So what you're looking at is from either Vermont's Acts and Resolves or the general statutes, where those historical laws are. So those are in the record. And I would just direct you to two laws in my testimony right now. The first would be the 1863 Vermont Gunpowder Storage Law. That's, I believe it's a general statute site that I've included in the materials. And that's a regulation that, very similar to here. It said if you have more than 1 pound of gunpowder in your house, it needs to be contained in sound canisters of tin or other metal. And if you're not, you would forfeit the gunpowder and have to pay a fine. And I point to this law because actually this law was discussed in the State v. Mish decision. And the Vermont Supreme Court invoked it to show how Vermont has historically passed laws that, quote, placed a burden on the ability to rapidly prepare and fire multiple rounds of ammunition. So the Vermont Supreme Court viewed this law as analogous to the regulation on large capacity magazines. That's another step, and I think it's a right step for the court to have taken, but it's certainly closer to these safe storage things we're talking about. It's, again, still about safe storage. The other law that I would point to is the one non-Vermont law that I included, which was a New Hampshire law about regulating the storage of gunpowder in Portsmouth, New Hampshire. One of the open questions in the sort of post-Bruin world is, what period of history do we look at? Do we look at just the founding? Do we look at just the 1868 Reconstruction era? Part of this idea is, well, the Second Amendment only applies to the states because of the 14th Amendment, and therefore, really what's relevant to history is those who adopted the 14th Amendment, what regulation did they think was tolerated under the Second Amendment? I don't want to totally delve into that here, because frankly, I view that as sort of getting to an angels dancing on the head of a pin sort of inquiry, but I've included some materials here that show both from the Reconstruction era and then also from the colonial era, these sort of laws. I would also note, so what is the safe storage law targeting? Well, it's targeting, possession by prohibited persons and children and making sure that they don't gain access. So in that way, I would also view this law as analogous to restrictions on possession of firearms by felons and also possession by children, by minors, which are, again, those sort of longstanding traditions mentioned in the Heller decision, longstanding regulations mentioned in the Heller decision that are presumptively constitutional. So that would be my analysis of the safe storage provision. I'm going to move on to the extreme risk protective order provision, unless folks have specific questions about safe storage.
Tom.
Brief question. 1863 safe storage laws, that was based in a time when there was no modern smokeless powder. It was all black powder and was considered an explosive, and it's still considered an explosive today. Modern sporting powders were not developed until at least 1884 and not used till much later. Do you think that would have some difference in storage?
That's a very good question. I will note that some of the laws that I've included are post 1880s. I believe there's, let me double check. I think there's the city of Rutland charter law comes from 1893, and I believe it's St. Albans, but the Montpelier, actually. It was the Montpelier charter amendment that's in the 1900 Vermont Acts and Resolves. So that comes from 1900. And again, they're all very similar regulations about the storage of powder, allowing for inspection, setting restrictions on height metal canisters, those sort of things. There's also one of the other materials I included is I guess this is predate what you would say. This is the 1876 St. Albans Charter. But suffice it to say, there are a few post 1880s laws in there as well.
Thank you.
No other questions right at that moment.
Excellent. Okay, so let's go on to the extreme risk protective order provision. So what that change does in H230 is it adds a family or household member as a person authorized to file the petition. So again, to go back to the three-part test or the two-part test, however you want to frame it, what is the proposed course of conduct that someone wants to engage in that would, lead them to bring a Second Amendment challenge? So the proposed course of conduct they'd be challenging would be purchasing, possessing, or receiving a dangerous weapon after a judge has found by clear and convincing evidence that the person poses an extreme risk of harm to themselves or another person. So does that proposed course of conduct implicate the plain text of the Second Amendment? And I will say strongly, no, it does not. The Second Amendment protects a right for ordinary law-abiding citizens to keep and bear arms, primarily for self-defense. Heller made clear that the Second Amendment does not prevent states from preventing dangerous persons from possessing firearms. And those who have been individually adjudged to be dangerous do not have a right to possess firearms. So I feel very strongly that this would fail at a plain text analysis. However, again, pleading the alternative, considering even if the plain text is implicated, it is supported by historical tradition, in part because these felon in possession laws and these restrictions on the mentally ill, they're long-standing prohibitions. They're the part of what's always been considered to be a part of the Second Amendment. There's an ongoing debate right now within the courts about whether, it talks about the right of the people to keep and bear arms. And there's a good amount of case law out there that says felons and those who have been found to be dangerous are not a part of the people protected by the Second Amendment. And this draws support from Bruin, where Bruin repeatedly talks about how the challengers in that case were ordinary law-abiding citizens. And those are the people we're talking about. We're talking about ordinary law-abiding citizens. And so when you have someone who's been adjudicated to be dangerous in this way, or to pose a danger for that moment, I think it is completely fair to say that they, and consistent with the idea of the plain text of the Second Amendment and historical tradition, to say that they do not possess a right to have firearms in that moment. This is something that's still percolating in the courts a bit. I believe there was a testimony at the last hearing from someone involving a New York trial court decision that found some problems with New York's extreme risk protective order law. What I would do is, I'm happy to discuss that case to a certain extent. What I would also say is, I think even potentially since that testimony happened, there was a California Court of Appeals decision that I've included in the materials that upheld California's extreme risk protective order law post-Bruin. And it actually contains a very lengthy analysis of why these laws are consistent with the Second Amendment, why they're consistent with historical tradition, that I think could inform your discussions today. Finally, on ERPOs, one thing I really want to stress, because I know there's going to be some discussions of, due process concerns in this area and the due process of a person who's going to have their, firearms stripped temporarily from them. And yes, that is a concern, and I believe that this law protects that. But I don't want us to lose sight of the other due process rights that are at stake here, and why I believe a family member or a household member should be allowed to directly petition in this way. A family member and a household member has certain unalienable rights themselves. Under the Article 1 of the Vermont Constitution, they have an unalienable right to life, liberty, and pursuing happiness and safety, pursuing and obtaining happiness and safety. If you're living with someone who is posing an extreme risk to themselves or to you, I would posit that that you have a right to go seek help from your government, to seek help from the state when there's a person in your house who's threatening you, who's threatening your life and safety. I would say that you have a due process right and that the state has a duty to step in and help you. And I believe that this is a way to do that in a way that balances these rights. So, let's not forget, yes, there's a fundamental Second Amendment right, Article 16 right to keep and bear arms. But there's also a fundamental Article 1 right and a 14th Amendment right to life, liberty, pursuing happiness, and obtaining safety. So the next thing I would move on to would be the waiting period provision. But if there's any specific questions about ERPOs, I'm happy to answer that now as well.
Any questions? Not seeing any. Go ahead.
Okay, great. So the waiting period provision that introduced in H230 is a 72-hour period before transferring a firearm. So again, what's the proposed course of conduct? So that would be transferring a firearm or receiving a firearm in less than 72 hours after the completion of a background check. So does that proposed course of conduct implicate the plain text of the Second Amendment? Again, my position would be no. The Second Amendment protects a right for ordinary law-abiding citizens to keep and bear arms primarily for self-defense. But Bruin made clear and Heller made clear that states could continue to impose commercial sales restrictions and background check requirements before a person takes possession of a firearm, and that commercial sales restrictions were presumptively lawful. And so, what I would point to there, the language I've been pointing to from Heller throughout. I would also point to Justice Kavanaugh and Chief Justice Roberts' concurrence in Bruin, where Justice Kavanaugh actually talks about licensing regimes that require fingerprinting, background checks, mental health records checks, firearm training requirements. He lists a laundry list of different requirements that states can put on in the commercial sale of firearms, and in the transfer of firearms, and implies that none of those are violate the Second Amendment. I would again also direct you to the Tolada decision. Now, the Tolada decision involves a person who was dealing in firearms. It was a person who was illegally dealing in firearms, breaking federal laws on that. And the court found that there was no Second Amendment right, no plain text right to engage in the proposed course of conduct of selling or transferring firearms, unrestricted being the key word. And again, in that decision, the court found no historical evidence was necessary. So again, pleading the alternative, let's go to the historical tradition. So even if the plain text is implicated, there's a lengthy historical tradition. And I think it's important to step back here for a moment and think, Bruin is an odd decision in that it requires us to imagine what the 18th and 19th century world looked like. And this is why I've included the Sylvester v. Harris decision. This is a Ninth Circuit decision, Court of Appeals decision, federal court decision from before Bruin, but it has a really important line about the history. This approved California's 10-day waiting period under a Second Amendment challenge. This is what the Ninth Circuit said in thinking about historical tradition and waiting periods. There is nothing new in having to wait for the delivery of a weapon. Before the age of superstores and superhighways, most folks could not expect to take possession of a firearm immediately upon deciding to purchase one. As a purely practical matter, delivery took time. Our 18th and 19th century forebears knew nothing about electronic transmissions. Delays of a week or more were not the product of government regulations, but such delays had to be routinely accepted as a part of doing business. And I think that's a key inquiry, because the idea is what would the founding fathers, or throughout the 18th and 19th century, what would they have considered reasonable? What would they have considered to be appropriate? And these sort of delays would be, that's just a part of living in that time. Sylvester v. Harris provides one example of that, but I also want to provide an example a little bit closer to home. There's a excellent book by Carol Sheriff, she's a historian, called The Artificial River, which is a history of the Erie Canal. And it sort of gives you an insight into what the world was like, at that time. Erie Canal was opened in 1825. And she has, I'm going to read it because it's really helpful to get a sense of just how slow things moved, just how, it took time for things to happen. And it would be completely understandable for there to be a waiting period in the purchase of firearms. So the Erie Canal made distances seem short, not so much with speed as with efficiency. Pulled by teams of horses, canal boats still moved relatively slowly. Those catering exclusively to passengers reached speeds of up to 5 miles an hour, while freight boats moved at about 2 miles an hour. Yet canal boats cut nearly in half the travel time between Albany and Buffalo, a journey that now took between 5 and 7 days. That's what the world was back then. A fast journey between Albany and Buffalo, which I checked on Google Maps would take you about 4.5 hours today, even with the snow, was 5 to 7 days. Commercial goods moved at a speed of 2 miles per hour, and that was viewed as a massive improvement and a fundamental change to society. So, Do I think that Bruin is the right way to think about constitutional rights? No, I do not. I think that the Vermont Supreme Court got it right in how they analyzed this. But, operating in the world that we're living under, if we're thinking through historical tradition, we need to think through the realities of historical tradition. There's a whole other conversation to be had about the racist, sexist, realities of historic tradition and how that informs all of the discussion. But leaving that to the side, the pace of life was entirely different. And a 72-hour waiting period would have just been expected. That would have been the idea of an on-demand firearm. It would just be a foreign concept. So that really concludes my testimony. Again, I want to thank you all for this opportunity. I'm happy to answer any questions, but really, what I'm here to say is Bruin does not say no regulation at all. There is still plenty of room for common sense regulation, and I'm happy to discuss that. I'm enthusiastically in support of H230. But I want you to all know, yes, Bruin does not stand as an obstacle to common sense laws like H230.
Great, appreciate that. Questions? Joe.
Thank you so much. I had a question because I'm still struggling to fully understand Bruin, as I think many people are. I mean, I think we've heard in testimony from people on all sides of this issue that, we are still in the early phases of trying to understand this decision, and it is. It's very helpful, to hear differences of opinion on this. The thing that I wanted to ask you, because one of the core elements of your testimony was about the three-part test that, as you pointed me to on page 15 of at least the court's opinion that you find on their website, that basically there's three steps. There is what is the proposed course of conduct? Is it covered by the plain language of the Second Amendment? And then, if it is, then what is the historical tradition there? And so you had given sort of an example using, when you're going through the different elements, you went through self-storage, and you said that this would not be covered by the Second Amendment. But I wanted to hear your response to slightly later in the Bruin opinion. This is on page 23 of the court's website opinion, which is section 3A of the majority opinion, where the court said, sorry, I'm just trying to, here it is. It's about halfway down. It says, nothing in the Second Amendment text draws a home public distinction with respect to the right to keep and bear arms. As we explained in Heller, the textual elements of the Second Amendment's operative clause, quote, the right of the people to keep and bear arms shall not be infringed, end quote, now they're quoting themselves, guarantee the individual's right to possess and carry weapons in case of confrontation. Heller further confirmed that the right to bear arms refers to the right to wear, bear, or carry upon the person or in the clothing or in a pocket for the purpose of being armed and ready to be offensive or defensive actions. And then it talks about some additional things as well. For example, most people don't have a holstered pistol on their hip when they're in their bedroom, so there might be some additional things there. I guess what I'm struggling with is I'm wondering if you could go into a bit more, given what the court said in section 3A, why you would think that a proposed course of conduct that keeps someone from being able to access a firearm, perhaps in a situation under duress, when there is an intruder in the home, and the proposed course of conduct here would to be able to access that firearm for purposes of self-defense, which is what the Supreme Court said is the central tenet of Heller. I'm sort of wondering why you would think that wouldn't fall under the Second Amendment, because I sure think it does. And so I'd like to hear you talk a little bit more about your analysis there.
Yeah, absolutely. No, and I will say in full candor that of these three provisions, I think that the plain text argument for the safe storage is the weakest. I do think that, I will concede that point heartily. I think there is an argument, in particular, as the bill is written, linked to, making sure that guns aren't going into the possession of felons and children, people who have, lengthy historical traditions of regulation upon them from possessing firearms. And so that's why, if I were defending the constitutionality of this law in court, I would certainly make the plain text argument, and I feel like it is a good one to make, because keeping and bearing arms for self-defense, it talks about defense of the self. It talks about, this. It's not necessarily about, defending others beyond yourself. I understand the hypothetical of the intruder in the night. That's the paradigmic example, I guess, that would play in of self-defense, defense of property, that sort of thing. But again, that's when I would go to the historical tradition. And I think for safe storage, where you have such a lengthy historical tradition of regulation, and not just at, the commercial grade. Some of these laws, are about like, and I think even some of the laws I've cited include provisions about, 50 pounds of powder. But then it goes to smaller amounts too, of 1 pound of powder, and even in those cases, it needs to be secured in a safe, canister. So in my view, I still think there is a plain text argument to be made, but I also think that in particular for safe storage, there is such a lengthy historical tradition. And again, I've really only focused on materials from Vermont. If you look across the country, I mean, it's 193 according to Duke. I actually even pulled some that weren't on Dukes for Vermont, so I'm sure there's more out there. That strikes me as one of those, one where there has been a tradition of historical regulation that would justify a law like this.
And to what extent, in your opinion, looking at these various cases, because again, this is actually, I'm going to ask you another question first, because I think it makes my second question a bit clearer. How do you think that historical tradition analysis ought to be done? When I look at State versus Minch, I notice, having read through this case, that the Vermont Supreme Court takes a very particular approach to what they call the historical context test. And in their historical context test, this is on page 8 of the Minch decision, or maybe it's page 9. The quote I'm looking for. I can't find the exact quote at the moment, and so I'll just skip trying to quote something here. But the court talks very much about how we need to think about and understand the historical context of the Constitution and the historical context of the statutes, and talks a little bit about how there's sort of different ways to do that. And I'm sort of wondering, how do you approach a historical context analysis of these? Are you looking at it from the perspective of legislative intent? Are you looking at it from the perspective of plain text reading? Mm-hmm. How do you approach when you're reading an old statute like that? How do you think we ought to be looking at that?
No, it's a very good question, and it's one that that is still very much open to debate right now. The way I would think about it is, there are times where, Bruin talks about how you don't need to find a historical twin, you just need to find something relatively similar. There are times where you do find close to historical twins, and when you have that, that's more, I keep it as sort of a plain text analysis sort of thing. And I would give as an example, the gunpowder storage and safe storage provisions. I mean, it's about regulating the means by which you use to shoot a firearm, to discharge a firearm. And it would implicate, the intruder in the night situation. So I do think that when you have situations like that, you can keep it to plain text and be like, well, look, back in 1863, we were regulating storage. We can regulate storage now. When it gets to, slightly more, reasoning by analogy, which is a lot of what what Bruin talks about. That's where I think you need to go into, and Bruin talks a little bit about this, the how and the why, the justifications behind the law. And that does go a little bit more to legislative intent. What were you trying to do? So keep it in the context of safe storage, why are there longstanding Vermont regulations about children possessing weapons or purchasing weapons? I think it goes back to the 1800s where they banned 12-year-olds from purchasing, weapons. Well, that was done out of a concern that, children would use them irresponsibly, that there was public safety, concerns. I remember an old newspaper article I read about an 11-year-old who, shot himself or shot his friend with a firearm back in Barton, or I can't even remember, so some town back in Vermont in the mid to late 1800s. And that illuminating thing of protecting public safety, protecting children from the discharge of firearms, is another one of the legislative policies behind the safe storage provision. So I do think that it would be analogous to say, look, we've always been concerned about children and prohibited persons coming into possession of firearms. This is just another means of achieving that same goal. That this is the why of why we're doing it, and the how is still pretty similar. We're trying to get at them coming into possession of firearms, and we've seen this development of people getting possession if they're not secured, if guns are not secured in the home. Therefore, we're adding this regulation. So that's where I think you can get a little bit away from the textual plain text analysis and more into a legislative intent. Why are we passing these laws sort of thing?
Great. Thank you.
Yeah.
So a couple other questions back to that concept that you were just talking about with Joe, as far as the first step, or was it the second step? I'm not sure if I'm following which step it was.
It blurs, yeah.
As far as in our bill, there's the exceptions as far as not applying if the firearm is carried by or under the control of an owner or another lawfully authorized user. It seems that that should be read into that the plain text of the Second Amendment protecting the proposed course of conduct, which that exception seems to be doing if we're talking about self-defense. There's a concern about self-defense, have the firearm on you or in your control. Am I reading that part right into that? It just seems to be something you look mainly at the main portion of.
No, that's an excellent point that I should have included, because yes, that does go exactly to that plain text. It's cabining. This doesn't implicate keeping and bearing arms in all contexts. This is why you have to define the proposed course of conduct, and I need to do a better job of defining the proposed course of conduct, because it has, if you're under the control, if it's being carried, then that does not implicate it by this law. So that's where a very specific articulation of the proposed course of conduct that would be challenged needs to be done, and really getting at what are you regulating, because that does make a key difference at that first step of the plain text analysis.
So the other question I had is, I'm assuming, because you didn't mention any, that we don't have any Second Circuit opinions that have interpreted Bruin or Vermont district court opinions.
There are no Second Circuit Court of Appeals decisions interpreting Bruin yet. There are several pending cases involving New York's gun laws that are sort of up on an emergency basis, where we should expect a decision in the next few months. There is one District of Vermont decision, Federal District Court in Vermont decision from Judge Rice, which I can pull up, involving the felon in possession law, the felon in possession federal law, from February. And let me just find that quickly. Yes. So that is United States v. Martin, which was decided on February 3rd, 2023. And it is, it's not in my written materials, but I could provide it to the court. To the legislature. You can see where I'm used to arguing.
We're the court of public opinion, really.
Sure, absolutely, absolutely. That's at docket number 21 CR 68 and is available at 2023 U.S. District Lexus 18413. And that could you send that? Can you send that as a PDF to us? Absolutely, absolutely, yeah. And just to preview, that's a case where Judge Rice finds that the federal felon in possession ban does not violate the Second Amendment. She does a historical tradition analysis, but she sort of shows how this plays out. So I'm happy to share that.
So one other question, the New York cases that are moving into the Second Circuit appellate process, do those involve any of the issues that we have in this particular bill, waiting period, safe storage, and the ERPO law?
I do not believe so. Let me double check. I pulled numbers recently. I think there's been about 250 Second Amendment challenges since Bruin was issued. So I don't want to definitively say that there hasn't one that slipped by me, but I believe the ones that are up there are more about New York's licensing laws, some of their sensitive place laws. Right. I don't believe there's a waiting period, safe storage, or ERPO one there, but I'll double check.
All right, great. I appreciate it. Karen, good question.
Yes, and this might be a question for you, Mr. Chair, and helping me kind of identify questions I need to ask, is I'm trying to understand our assignment in determining the constitutionality of this. Like, is there a certain threshold we're getting to? Because I feel like we're going to be just hearing from all the different sides, and it's a gray area. And so for me, it seems very clear, like, what we pass is going to be going to the courts. And so, like, I want to make sure it is, at least hearing from some people, that it is constitutional. Because I'm hearing clearly on the other side, from the health and wellness side, like, these efforts are going to make a huge difference for Vermonters. So I'm like, as long as I hear there's some people out there that think that this can pass, I'm like, supporting it, but I'm trying to understand what is is there a certain threshold we're trying to achieve or?
That's a good question. Probably not one for this particular witness. And so that's also something open to committee discussion. I think what we've heard, though, from particularly legislative counsel is, and he's where we get our main legal advice from. And it's essentially, we don't know where this is going to go. So to me, at least the way I'm looking at it is, do we have a legitimate and good argument for why this is constitutional? And I think I've certainly heard that today and feel that we have that. If it was a clear, that we didn't have a good argument, that'd be something different. But so that's kind of the way I look, is that how good is this argument? We don't know how it's going to come out at the end, but do we have a legitimate argument? And, that's at least my judgment, but other folks have to make their own judgment on that as well.
Okay, that's helpful, because I just feel like a lot of bills and stuff we consider, we're not doing this extra step of necessarily considering the constitutionality of it. I mean, maybe we are in general, we just know that Leg Council is writing things that are. So this is just a different step for me. I don't know how far to dive into questions. I'm like, okay, lawyers seem to think there's something to run with. I'm good with it.
Right. I mean, and of course, we have our own duty under our oath to respect the Constitution, not do something that's unconstitutional. And I'm not hearing that we're doing anything unconstitutional. We won't know until some court, either the Second Circuit or Vermont District or the U.S. Supreme Court, comes out on this. On the Second Amendment side, we already have, I think, pretty good precedent on the Article 16 side. So, but that's also why we're bringing in different viewpoints, and I'm hoping that Rebecca Turner will, in fact, provide a counter argument to probably what we've heard. So, not putting pressure on you, Rebecca. So, and we've already heard some counter arguments to that. So I think we're good with this. Should we try to get one more witness in before a break, or do folks need a break now?
I'd love to hear from Rebecca.
Well, but she's not until after Rory. We have to go through Rory first to get to Rebecca. So.
I'll be gone the rest of the day.
Let's push through then. So maybe there's a chance you
all right. So Rory, we'll have Rory. Thank you very much, Billy. I really appreciate it. We'll look for that information from you.
Thank you all so much.
Thank you.
Thank you.
All right.
Well, good afternoon, Mr. Chairman. And for the record, I'm Rory Tivo, former State's Attorney for Washington County. I'm presently working for the Department of State's Attorneys and Sheriffs. It's always a pleasure to be in House Judiciary among great friends like Representative Ghostland. I'm glad to see you as well today.
Nice to see you. Nice to see you too.
So I'll start in a very broad brushstroke. I think the testimony here on behalf of the department today is going to be a little bit different from the broad policy perspective and also the constitutionality. What we're primarily concerned with are the sort of pragmatic impacts of this on the court system and how prosecutors would interface with this, given some of the new criminal penalties proposed, a legal standard for safe storage that may have an enforcement mechanism attached to it, and also some of the public safety aspects that accompany this bill beyond just the public health component for which it was proposed. I want to start by noting first, there was a supplement to our testimony that was posted, I think, to the committee page either last night or this morning. And there are some more technical details in there about proposed language or some of the issues I'll discuss. But I think a great point to start with is really the definitions within safe storage. And I'll just note that the department doesn't take a firm position on what the safe storage standard is. That's really a policy question for this body to decide. And moreover, technical experts, whether from public health or public safety, law enforcement background, would probably be best suited to work out the exact details of what is or is not safe storage. But with that said, having clarity in definitions is critical. And Chairman Lalonde appropriately pointed out, what is the concept of control? When interfacing with the notion of self-defense, is that some sort of physical control? Is it constructive control? How this body determines that or further defines control may assist in assuring the constitutionality of the overall bill. But moreover, for prosecutors who are stuck or in a situation looking at how to apply this law, it will provide a greater degree of certainty and also notice to individuals who are subject to the safe storage standards. So I think the main points there would be to consider whether there's further definition needed about whether we're talking about physical control, constructive control, and what the parameters of that are. There's some other scenarios which may be beyond the scope of what can be legislated, but just for a hypothetical, whether is there a difference between a firearm that is unloaded versus loaded? Right now, there's no distinction made, and it's only noting that ammunition needs to be stored separately from, firearm. So working through some of those nuances may be appropriate before the bill is assuming it leaves committee for the full House to consider. Turning then to the next component of safe storage are really the penalty schemes. And this is an area where a lot of the comments in the field, and I'll give specific regard to State's Attorney Sullivan in Rutland County, State's Attorney George in Chittenden, who provided some really useful feedback to our department's analysis. First question is really with the lowest level of potential liability. That is just a baseline violation of safe storage. Right now, the proposal includes a fine-only offense. What's important, the important policy decision for this committee to determine is whether some of the collateral consequences of creating a new criminal offense are desired here. And I put that out in the context of search warrants. So in order to obtain a search warrant to look for, go into someone's house and check for compliance, that would entail a criminal violation having occurred or some other carve-outs. So the question is, if this is even a fine-only offense that does open the door, what some could perceive as overreach by law enforcement or prosecutors to actually look and try to proactively enforce safe storage if there's some notion or probable cause found that someone may be in violation of it. The alternate that we proposed or suggested in our discussions was maybe considering this to be a Judicial Bureau violation for a first offense, and then if there's a desire to have some mechanism for criminal enforcement, that be reserved for a second or subsequent offense, meaning there would be no default right to go and apply for a search warrant for compliance. For the remaining two, whether...
Can I ask you a quick question? So are you talking about that for just the fine, not more than $100, the subsection B1 or B2 and 3?
The comment here is just for B1. And then with respect to B2 and B3, there are the issue, of course, that this is one of those rare circumstances where, as written, it would be creating effectively a strict liability felony offense, particularly in B3. With B2, our main concern was really about the choice of language, that there is no other place in Vermont statute where the particular language used or used in a threatening manner is somewhat undefined. Our recommendation was that it would just be limited to looking at criminal offenses. And noting again, if someone is, brandishing or waving a firearm in a menacing manner, then that would be subject to potentially disorderly conduct, criminal threatening, aggravated disorderly conduct, or, potentially reckless endangerment. So again, just wanting to avoid any degree of vagueness or any basis to challenge what's there. So recommendation is, at least in B2, striking the latter part of that definition. There was another concern, and this was raised by State's Attorney Sullivan in Rutland County. His concern is that right now, without modification, this statute could be used to punish the parents of children who use a firearm to commit suicide. Particularly, there's current language that says, and to use it to cause death or injury to any person. That could include self-inflicted harm. The recommendation here is relatively simple, which is to insert and to use it to cause death or injury to any other person, which would remove the prospective liability for a parent in that tragic circumstance.
Could I back up?
Sure.
Real quick, and then Angela has a question on that. The displays it in a threatening manner. Do we have a brandishing law, a brandishing offense? So it would have to fit into reckless endangerment?
Reckless endangerment, disorderly conduct, aggravated disorderly conduct, or criminal threatening, all of which have non-specified conduct components that result in fear of either bodily injury or serious bodily injury by a third party.
So the problem with displays it in a threatening manner is it's vague?
It is, and it's really unmoored from then any other statute that we presently have with the lack of a formal brandishing offense. So reckless endangerment, just waving a gun around, would not meet the essential elements. Pointing it at someone would. So really, it's lack of a better way to put it, there's some combination of intent with behavior or conduct that underlies each of these criminal offenses. And so what is a threatening manner would be undefined and not linking back to any existing criminal statute.
Okay.
So I think the reference simply to use it in the commission of a crime would be a sufficient basis to.
Right. How about if it's not in here, it's something I think was taken out of the bill as I think may have initially been introduced in healthcare, where they also included discharge as the weapon. So this is a B2 again. That uses it in the commission of a crime, discharges the weapon, or displays it in a threatening manner. But putting aside the displays in a threatening manner, what about the concept of discharging the firearm, having that as in that list?
Yeah, so under, within, I can't remember the chapter offhand, but I think it's 13 VSA, maybe 408 is negligent use of a gun. There's a criminal statute that pertains there, or negligent wounding another, and then there's also a simple assault offense. All those really are centered upon actual injury. The only other offense that captures the discharge of a weapon where there may be recklessness would be reckless endangerment. But we don't have a simple negligent discharge type offense or anything like that. Of course, in my prior life under the Uniform Code of Military Justice, there's any number of offenses geared towards individuals who misuse a firearm, but that's a really different system than here in Vermont.
Right, but here it's a child or a prohibited person accessing the firearm and misusing it. So I'm less concerned about actually being a commission of crime. It's that the child has gotten access to it and has misused it, not given access to go hunting, but has discharged the weapon, has waved it around, threatening manner, et cetera. So, all right, I appreciate it. So, Angela, I think had a question on that.
Yeah, thank you. Hi, I was just wondering if regarding, what are we now in B3, if your recommendation would be to strike B2C. Am I doing that right? The charging discretion.
Yeah,
That seems to cover what you were talking about, but.
Yeah, so a number of state attorneys and our central office review is also thinking that that's somewhat unnecessary. That'd always be a consideration by first and foremost in making a charging decision. It's also a relevant factor in mitigation if there were a charge. The court would almost certainly consider that. And I think there's a very strong view that most prosecutors would not consider charging a grieving parent under those circumstances.
Okay, so it seems, what I'm hearing is that I think there's alignment between what you've shared and what the intent is here with the charging discretion. So you're suggesting just align it all in that B3.
Yes.
By changing the language to
inserting the word
other person.
Correct, and then striking C would obviate that.
Thank you.
Thank you.
So that leads me to another question, which is, I get the concern about C. There might be times that it's where somebody takes a gun that they shouldn't have access to, brings it somewhere, shoots a bunch of people, and then commits suicide. Or it's unclear if somebody died from a self-inflicted wound rather than suicide, or a babysitter gets, so I'm a little confused about what removing that section would do in terms of when it might be appropriate to charge, even though it might look like one's own child.
Right.
Not themselves.
So you're specifically referencing then the subpart C talking about charging discretion.
Right. If that gets taken out, does 3, when it's saying another, would that mean, again, with being sensitive to the protections that you identified, not sort of swooping in too many things that might be like, okay, this is punishable for
I guess the way to look at it is, with or without that language, there's still nothing that precludes the independent review of whoever the prosecutor is, whether to charge or not charge. In terms of mandating that there be a consideration, I don't want to say, I hate the term a slippery slope, but I don't think in a circumstance like this, a prosecutor is ever going to make a decision without assessing the totality of the circumstances. And so I think, really our perspective was it's surplus language and doesn't need to be prescriptive.
Thank you, that's helpful.
So on that subsection C, if at a minimum we change the shall to may, because first of all, we're talking about charge and discretion, and we're suggesting of taking kind of away the discretion. Does that temper that at all? Does that make it any better if we at least do that?
I think the may does. Of course, it's not then. It's part of that. And
it's almost like sending a message. You may do it already, but it's within the context of what we're talking about here. Because my other issue, and we have to maybe talk as a committee a little bit about this, is like, I know that the healthcare committee looked at just this very question, and do we defer to them on saying any person? Because I understand that they did consider this and made this decision. So we would be going against that decision, and then who should really make that decision? But that's not for you, but I just wanted to alert folks in the committee to that. Ella.
Yeah, maybe I'm missing something, but I think if we make the changes from any person to any other person and strike the charging discretion, then if a child goes to their friend's house and accesses a gun and commits suicide, there's no repercussion at this level for the adult who did not safely store their weapons. So I think I don't see what the whole point of this bill is suicide prevention. So I feel like maybe something got missed, or maybe I'm missing something.
Yeah,
I don't think your proposal sufficiently protects people from suicide in that scenario.
Okay. It's really then a question, I would just, posit back then, it's really a question then of a policy of just to what extent does the legislature wish to extend criminal, liability. So that is the consequence, that you could have a prosecutor elect to charge a parent in that situation versus someone else. So I'll say this, I don't think we have a hard position on that. It's just a consideration that we want to make sure everyone is aware of before advancing the bill.
Yes.
Thank you.
Certainly in terms of C, the final point I would just say to the chair's comment is there are a lot of times when we will look to things like that or may consider, or for example, in the context of domestic assault, 13 VSA 1047 allows the court to consider whether a child is present during the commission of the crime. It really is, from our standpoint, signaling by the legislature in terms of what's important when making decisions or looking at sentencing. So there's still a lot to go in the bill, and I think one of the areas we have some more comments as well, of course, is with extreme risk protection orders. And I'll just note that the department at this point is supportive of allowing for family or household members, and we can discuss the definition of household members a little bit here as well.
I'm sorry, can I ask you another question? That previous thing, I was just trying to find something that made my question make sense. So on the section we were just talking about, B3, it's caused death or injury to any person. And if you look at, which is page 5 of draft 4.1, it defines injury means a harmful effect on the individual's health, including the individual's mental, emotional, or physical health, or a combination of these. I was wondering what you think about the interaction of this section B3, and specifically referencing injury, to how injury is defined. And the reason I'm asking the question is that I feel it's a very broad definition of injury. Any harmful effect on mental, emotional, or physical health, or something like that. It just seems very broad. I'm sort of curious how you felt that would be used prosecutorially, this broad definition of injury, and also what you thought about, is its broadness sort of okay from a sort of judicial oversight standpoint?
Yeah, so first, of course, you correctly noted that this is a departure from what we normally consider, which is bodily injury, which is some sort of pain or whatever caused to somebody. Looking at the more mental, emotional duress, I think covers situations where a gun is, say, brought to school and there's a threat against other children without any resultant harm. But but for the negligence or neglect of the gun owner, that would not have occurred because the child or the person wouldn't have had access to it. So we read that as being consistent with the overall policy goal here. And it is, again, distinct from what we traditionally look at in terms of bodily injury. From an enforcement or from a proof standpoint, it seems to me that this isn't something that would exclusively require, say, expert testimony. There's probably some inferences that can be drawn from, duress or what someone reports of, needing, counseling or the tumult of the experience. So probably a combination of both of, testimony from an impacted person and or potential medical records or expert testimony about the impacts would be what I think a prosecutor would rely upon to meet that standard at trial.
Great, thank you.
So moving on to the extreme risk protection orders. There's a lot of discussion about what those definitions are of both family and household member, and that may be one area where there's a bit of a caveat. But at a baseline, the department does not object or oppose to family or household members being able to seek at least a temporary extreme risk protection order. And this is where the beginning of caveats or reservations come in. I'm aware that some other stakeholders, including Judiciary, are concerned about just the breadth or the ability of a family or household member to meet the evidentiary burden in a hearing without counsel. Moreover, the ability to secure witnesses or issue subpoenas. What we looked at was perhaps a hybrid of this, and our proposal or suggestion to the committee to consider is allowing for family or household members to initiate and obtain a temporary order, but that a final order have the state's attorney or the attorney general added as a party. This would really mirror the existing system with an emergency involuntary adult guardianship, where those are frequently sought by either a family member or some non-participant in the criminal justice system or the law enforcement system. We borrowed language, and it's in the supplement from Vermont Rule of Family Procedure, a mouthful, 6.2, which deals with the court's obligation to notice the state in those circumstances. And so this would require that upon issuance of a temporary order that the state's attorney or attorney general receive notice of the hearing and then basically be faced with the choice of assuming responsibility for the action or then dismissing it if there's a view that there's an insufficient basis to proceed to a final order or not. The view here is that this is consistent with the goal, which is in reality that frequently it's going to be a family or household member, someone close to a person. And I think this is more looking at suicide prevention versus those violence prevention ends of extreme risk protection orders. People in the household are probably best situated to know the particular circumstances, will have heard or seen the indicia of suicidal ideation or other markers that someone is unsafe with their firearms. And of course, I think this committee has heard before that there continue to be Vermonters who are reluctant to engage with or directly seek law enforcement assistance, even when some of us may have no problem doing that. So in this sense of opening the aperture for a greater number of greater access, we're supportive of that. But we believe that should be countered with including the state as a party thereafter to really handle or assume responsibility for seeking a final order. Beyond that, so we did propose what that language could look like in terms of amending both section 4053D and 4054B1, further beyond the amendments proposed in H230. There are a number of other things that we've internally looked at over the course of the past few years with the extreme risk protection order becoming more I think more commonly accepted and understood and utilized throughout the state, and looking at ways in which that can be more useful. This may not be the right opportunity, the right bill for the legislature to take a look at that, but other ideas were considered were clarifying the time at which or what the standard's based upon. So for example, this past summer, I litigated an extreme risk protection order. Judge Schoonover issued a decision that said, effectively saying at the time that the temporary order was issued, there was an extreme risk. However, over a month later, when we had our final hearing, circumstances had changed and she therefore declined to issue a final order. So clarifying that it should be based upon the conditions, the present conditions, or that a threat was posed at the time the temporary order was granted or the initial order was sought may help assure these are used discretionarily on courts to issue orders for up to 1 year, which we are practice with relief from abuse orders, may also be helpful to avoid having to come back so quickly. And final point we'd make on this is really just, again, looking at the definition of household member. So household member right now is a very broad definition. It includes past dating relationships. That has a lot of utility in terms of seeking an abuse prevention order or enforcing domestic or sexual violence offenses where there's an enhancement for a person being a family or household member. Here, further attenuation of the relationship or time away from the relationship may not be desirable. So whether there's a desire to caveat or look at a present household member versus a past household member may be something that the committee wants to consider as well. Again, we don't have, the department doesn't have a firm take on that, but it's just something we wanted to flag that may alleviate some of the judiciary's concerns and others about limiting who the scope of knowledge is to seek one of these orders.
Joe.
Could you explain this process a little to us? Because I sort of clued in on a similar thing that you were cluing in on, that which we're making it very broad. And so I'm wondering, as things presently work, it has to go through a state's attorney or the attorney general's office. So there is some sort of initial sort of glance at it by that professional. Would your understanding of the bill as written mean that sort of anyone who's defined as a household member, which includes former dating partners, as you point out, is just able to go to the court and say, I need an extreme risk protection order because X, Y, Z occurred? And then what would be the next steps then? Is there then an ex parte hearing, or what happens after that petition is filed?
Sure. So under the existing system, most of these, to be completely honest, most of the extreme risk protection orders I've been party to are a lot of times people just not knowing what to do with the situation where the conduct or what's happening doesn't rise to the level where someone needs involuntary treatment. It also doesn't rise to the level where there's any kind of criminal offense. And so it's this, in a way, gray zone where neither our mental health authorities nor our criminal justice authorities apply, but there's still a palpable risk to that person or others. In those cases, it's usually law enforcement who makes the call to us to ask, for advice as state's attorney. Like, one, do you think there's a sufficient basis on these facts to seek an order? And when there is, then we kindly request that they provide an affidavit and then follow an after hour. Whether in court hours, we'll go straight to the court. If it's after hours, we'll follow an after hour procedure to contact a judge. Typically based upon a petition, which is just a PDF form with that the judiciary has available, and then the affidavit. Court will make an initial finding. So if there's a preponderance of the evidence, they'll issue an ex parte order that'll then go to law enforcement to go serve the order on the respondent or the person involved. That will also include notice of when the hearing is to take place and if there's going to be a status conference prior to a final hearing. Under this model, as we're proposing, as the bill proposes, that would occur with the family or household member filling in the role of the plaintiff, or effectively what the state's attorney or attorney general does now. Our proposal on top of that would be, so great, we have a family or household member seeks and obtains the ex parte order from the judge, and then it's incumbent upon the clerk to then notice and include and basically substitute the state's attorney or attorney general as the plaintiff and the party, and then have that family or household member then cede their party status in the case.
And so, I can imagine just sort of knowing a little bit about prosecutors and things like that. In general, prosecutors, and correct me if I'm wrong, sort of tend to look at something and ask themselves the question, like, does this meet sort of an initial read test? I think that there is a preponderance of the evidence that there's a problem here. And so I'm going to bring this to a judge and hope that the judge goes with me. A family or household member may very well not have the knowledge to be able to do that analysis. So they're just essentially coming with, here's my concerns. They filled out a form and these are my concerns. How have you seen the actual interaction with the judge taking place? Because what I'm sort of trying to get at this point is sort of, if you're having an ex parte hearing, then the person's not going to be there to defend themselves. And the person who's going to be prosecuting this could even be an ex-dating partner. And so how do we, have you seen judges do I'm just wondering if there's only one person there and that person doesn't have the the legal training to be able to sort of say, yes, I think this meets these things for these reasons. How could you meet a preponderance standard almost?
Well, I think fortunately we see this happen every day in Vermont. It's very similar to how someone would seek an abuse prevention order or an order against stalking or sexual assault. Those are almost exclusively pro se litigants who are going to a courthouse, filling out a form, swearing to it, and then submitting it to the docket clerk. Sometimes, fortunately, the assistance of a domestic violence advocacy organization or someone else in the community. But from my perspective as a prosecutor, we see that work well just by virtue of how many abuse prevention orders we do see issued each year in the state. So people are able to navigate that. And, to articulate a preponderance here, again, it's someone swearing subject to the pains and penalties of perjury. And, most frequently we're going to see is, let's say it's someone's son for the sake of argument. So it would be, my son, Joe Smith Jr., has been depressed lately, has stopped, taking medications, and, lately has been talking about wanting to die and has recently been fixated on, acquisition of a firearm or, has shown undue interest in firearms or has threatened to, end his life and, some point, whatever that may be. I think that there's just as much as we expect someone seeking an abuse prevention order to be able to articulate to the statute. I think people in plain language can often meet that standard, at least at a preponderance, which again is more likely than not. And that's part of the why an ex parte hearing is a temporary order, and why then at present there's a higher standard to get advanced to a final order, which is clear and convincing evidence. So that is a much higher burden, and that generally does require, from my perspective, a higher level of analysis and really obtaining a better quantum of evidence to make sure, one, that it's admissible evidence that the court can consider and not just, statements, including potential hearsay from an applicant.
Great, thanks. And let's say an ex parte order is issued under the current system that's served and the person owns firearms and they're in the home. How does that process work? Do they then surrender them directly to the law enforcement that's there? And then if the permanent order isn't proven by clear and convincing, how do they then get those back?
So you've highlighted a really great point, and might be worth soliciting at some point. Again, I know this isn't a whole reevaluation of the extreme risk protection order system, but it may be worth soliciting input from law enforcement. And I'd say right here in Montpelier, multiple officers here have had to navigate the tricky waters of not having automatic right to go and do a search warrant, let's say on a house, incident to a temporary order being issued. A lot of this is reliant upon the voluntary compliance of the person or other responsible adults in the household, identifying or helping facilitate the transfer of those weapons. When they are transferred, they're temporarily, held. In the statute provides several mechanisms where they can be held either at certain licensed bodies, or the agency itself will hold them. Most law enforcement agencies do not like holding on to others, firearms for a long period of time, but that is how the system is set up. And of course, once, if a final order is denied, then that person would be, if not otherwise precluded by subsequent conviction or anything else, would then be entitled to immediately recover and retake possession of those firearms.
Thank you. Angela.
Thank you. So I just noticed that in section 4053, we again see the notion of a weapon being within a person's custody or control, line 18 and 19. And I just kind of keyed in on the word control there and wondered if you've seen that word in this context effectively understood and defined. And would that inform the understanding or definition of the use of under the control back in the secure firearm storage?
So
it shows the ambiguity.
It does, and I think
control is meant differently here in Urkel law. But go ahead. I'm sorry.
Right. I agree. I think that context matters, and this has been the question, of course, too. When looking at for example, this is a situation I did deal with. I'm working on an extreme risk protection order with someone who is a member of law enforcement. Duty weapon and access to where they work versus their home. How do you differentiate that, and what constitutes custody and control? And that circumstance is somewhat unique versus, someone's home. When we look at custody and control, this has come up several times where someone has multiple residences or may cohabitate someplace and there are other firearms in the house that don't belong to that person. These are all really challenging issues that typically require law enforcement and state's attorney to have common. And the one case I'm thinking of where it was someone cohabitating with someone who was a lawful firearm owner, that person under the circumstances just voluntarily agreed to remove their firearms as well to someone else's house. And that's again where that person didn't necessarily have direct custody or control of that other person's firearms, but they still had proximity and potential access. And that was, thankfully that person did, I think, the right thing under the circumstances. But those are really complicated questions of what do you do if there's 4 housemates and all 4 own firearms. So it sounds like it's been handled, I don't know, is it fair to say on a case-by-case basis with extreme risk protection orders? I think so. And I think what's safe to say as well that we have very limited case law dealing with either contested issues of law revolving around extreme risk protection orders. And last year, I think we only had 20 statewide. So there's not a lot. And as Tim, who used to work in my office, can attest, he handled a lot of these for us. They're frequently not contested at the final hearing because people realize, that there's a problem or are already on the path of seeking something, or other events have overtaken it where they've begun a course of treatment or they now have criminal charge of some flavor and there's conditions of release that make it more academic to have the order. So I say all that just to point out that we don't have a well-developed set of case law yet really addressing some of the nuances of what the limits of these definitions are. So would it be advisable then for us to try to define it in the other instance when we're talking about secure storage? I think for secure storage, yes, because that's a standard which a prosecutor is going to look at potentially, not just for purposes of violations of what's there, but also if the worst does happen, does it rise to a level where the person's acts or omissions constitute reckless endangerment or potentially an involuntary manslaughter in extremis? And the footnote on page 1 of our supplement provides the model jury instructions on both of those offenses. And I'll give you just a quick take from involuntary manslaughter. It is premised with this: criminal negligence means something more than ordinary carelessness. It means that the defendant disregarded a risk of death to such a degree that his or her failure to perceive it, given the circumstances, involved a gross deviation from the standard of care that a reasonable person would have exercised in the same situation. By establishing the safe storage standard, what you're really providing for the state, for prosecutors, for whoever to look at, is really what that standard of care is. Because right now it's not clearly defined either by case law or anywhere else in statute. So in that sense, the questions of actual physical custody or control versus constructive possession or control of a firearm are really integral, because that definition is going to guide whether there was that deviation from the standard of care. Okay, one more question, I think, and just stop me if I'm just like going down a wormhole unnecessarily here, but that makes me want to, is it reasonable to think that by defining control for purposes of secure storage, that we might in effect define it for other areas of this law or law in general? Yeah, I think you deal with two different, I think, again, contexts of where this is really, safe storage is a question of physical, actual, the modality of how things are kept or not kept or whatnot. For purposes of the extreme risk protection order, the real question is about access only by the person who is the respondent or who the order is against. So in that sense, it's slightly different, because it's that own person's access to their own firearms vis-a-vis third-party access or use of firearms. Although, in the exception, I think you're talking about that person's access, their ability to access their firearm, like quickly. Right.
Versus it's in the neighbor's house, or it's in your hunting camp, down, where you have control over it really, but it's not readily available. And we have, some of the other states have defined control a little more specifically in the context of secure storage that we can take a look at. But definitely the point is there, we do need to define control in the safe storage, and that shouldn't affect, because it would be just for that provision, what we mean by control, won't affect what's in the ERCOT law.
Okay, thank you. Thanks for
Very well.
traveling down that road.
No problem.
So I have a technical question for you, and this is actually from your proposal, and the question of jurisdiction and venue that you raise in your proposal.
Yes.
As far as there's some confusion if you have family or household member in section 4052, which is section 5. And I think there's one of two things that can be done, but here's the point, is that the way that it's set up in your proposal is when that ex parte order is issued, or if the individual seeks a final order, seeks it under 4053, not 4054, it is sent to the state's attorney. Now, presumably the question is which state's attorney is it sent to? So if the family brings the case in Chittenden, the respondent is in Addison, does the Chittenden person send that information to the Chittenden state's attorney? So it seems to me that one of two things. We either say in your language that this information, the petition, et cetera, is sent to the state's attorney for the county of the respondent, just to make that kind of clear, or we just strike family or household member, from section 4052. In other words, you have to bring it where the respondent resides or the county where the events giving rise to the petition occur. That's really where it should be anyway, because that's where, if there's an order issued, the law enforcement in that county, presumably, is going to have to serve it and have to deal with it. So one of those two things, it seems easy to me to just strike family or household member from the jurisdiction and venue. But maybe there's a time where you want the family member to be able to easily access the local court. That would suggest that we say send it to the state's attorney for the county. Do you have an opinion about which of those two approaches to maybe take?
I think the ultimate goal is just to make sure that when the appropriate prosecutor and the appropriate venue would generally be where the respondent is presently located or where the order would be served. I think, as you noted, our concern is also that at the same time, to open up this aperture to have family or house members apply, it doesn't make a lot of sense if you have a family in Bennington who is worried about suicidal ideation of their child who lives in Orleans County. The burden on them to then drive 3.5 or 4 hours north to make a filing would defeat really a lot of the flexibility of the purpose here.
But the final, if the ex parte order is issued in Bennington, the respondent's in Orleans, they send the petition to the Orleans state's attorney. Do they then, as a first step, change venue, or is that just where they file for the final?
So I think a provision that clarifies that filed elsewhere, then venue shall be where the respondent is domiciled or served, and then handled by that appropriate prosecutor or the attorney general, as it may be, would maybe be the best to preserve access to family or household members, but also to, I think, minimize the burden on both the respondent and then make sure that the prosecutor's handling the case has, I think, probably access to the best evidence and or jurisdiction over that person.
So something more than just putting sent to the state's attorney for the county of the respondent. You have something more in mind there. And if you do, since we're operating in a short time frame, can you?
I could certainly try to tailor some language for you, sure.
All right, just a proposal. Okay.
Happy to.
So I don't think you've talked about the waiting period as one part, unless other people have questions on the ERPO.
All right, so the final is the waiting period. And this is one of those parts of the bill where I think that it's notable that there's not just a public health component here, but from a constitutionality analysis and also a holistic analysis, this is one area where we identified a direct nexus to public safety. Some of you may be familiar with the term straw purchase, where a third party is basically sent into a gun store to acquire a firearm. That can be frequently done when somebody doesn't have residence or ties to the state of Vermont and would have difficulty acquiring a firearm on their own, or alternatively when the person's a prohibited person. Unfortunately, one of the most frequent situations I saw as a prosecutor with straw purchases, which unfortunately occurred here in this county, not frequently, but enough where it was of concern. What we typically see was exploitive behavior on somebody with substance use disorder where they did not have cash available, but they had a clean record. And so instead of a cash transfer or paying cash for whether fentanyl or cocaine or whatever their drug of choice was, a dealer or somebody else would bring them to a gun store, send them in with money, and then an idea of what they wanted to acquire. The person would then acquire the gun and then immediately transfer, hand it off to somebody in exchange for substances. And so that unto itself has an exploitive element to it. Our view is that a waiting period for firearm transfer would really discourage that type of behavior and remove the ability to have instant gratification, if you will. Our view was that it would really cut down on the ability for someone to prey upon or exploit somebody who's going through withdrawals or is desperate for acquisition of a substance to engage in that type of behavior. There are other law enforcement witnesses who probably be far better to talk about the phenomenon or what the prevalence of these straw purchases are in the state of Vermont. But a waiting period isn't just, there's absolutely a public health benefit here of, putting a cooling period down for someone who is going through crisis or has suicidal ideation. But it also has, I think, a side benefit where that immediate or instant gratification with a firearms purchase would be broken and would disincentivize or at least make it more complicated to do these type of transfers here in the state. The only other point that we noted is, the utility of a waiting period is somewhat different when you're looking at a new entrant to gun ownership, when someone who's never acquired a firearm before versus those who already own firearms. And although it goes beyond the scope of our department's role, we certainly are cognizant of the politics that surround any kind of gun safety or gun control legislation. And at least in Tim's conversations with I when preparing for this, we're cognizant that it would be unfortunate if a really solid or good bill with the public health benefits it has stalls out because of concern about this impacting the rights of sportsmen or existing gun owners. So the committee perhaps can consider whether there are means by which individuals who can already prove or validate that they're firearms owners, whether by virtue of a hunting license or whatever criteria are developed, are not subject to that. Because again, if someone already has firearms, we're not really achieving the same policy goal through that restriction. And our view, again, we're not the constitutional law scholars on this, but our view as well is that would be another means to inoculate this against some of the potential challenges or view that the restrictions were unduly burdensome on the rights of individuals to bear arms and effectively treat a new purchaser differently from someone who's established a history of responsible firearm ownership.
Okay.
Thank you for bringing these two situations up. And I guess my question is, there's part of me that's like, okay, yeah, this is interesting to think about, but do they conflict with each other? Like you're talking about the straw purchase where somebody could be used to buy a gun. Well, so to say they do it one time, right? So now they have a clean record and they are also now an established gun owner. So now they can be used all the time. So I feel like they conflict with each other. And so it just makes me think that there might be a lot more question and discussion than we have time to answer in this 1 week. But I appreciate pointing out both because I think there is more to it. But just those two, is that correct in how I think?
No, I agree with you completely. And, all this is, all this complicated and I don't envy, we're lucky we get to live with whatever you pass. But honestly, the discussion is important because there are trade-offs with each course of action, and in one sense, enhancing the survivability of this to constitutional challenge may result in a less effective bill. Conversely, having a more effective bill may lead to much longer litigation or risk that components of this are struck down.
Thank you.
Any other questions? Thank you very much.
Thank you so much.
Thanks so much.
So we're fully attentive when Rebecca testifies, should probably take a 10-minute break. So let's adjourn until, I know this committee, 1:15, but we